Privacy in the United States, US, is complex. This detailed video explains why. You see, the right to privacy has been a hotly contested issue in the United States for years. This is because the Constitution's Bill of Rights does not explicitly provide a right to privacy. However, this right has been upheld by numerous courts and is vigorously pursued by organizations such as the American Civil Liberties Union (ACLU). As a result, many federal laws, many enacted in recent years, are designed to protect the private information the government maintains about citizens, as well as key portions of the private sector, such as financial, educational, and healthcare institutions. This video will cover all these laws across all these sectors, with some useful tips and background context which I found useful in my revision for the CISSP exam. As a useful introduction, here are some of the laws that this video will be covering in some detail. Note, these will mainly be federal US laws. However, there are state privacy laws and various European Union laws, which is not going to be covered in detail in this particular video. However, will be covered in a upcoming video. So please be sure you have liked and subscribed to this channel if not already. Now, let's go back in history and understand the USA's Fourth Amendment of the Constitution, which provides the right to the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures. And the main important takeaway is probable cause, meaning the direct interpretation of this Fourth Amendment prohibits government agents from searching private property without a warrant and probable cause. The courts have expanded their interpretation of the Fourth Amendment to include protections against wiretapping and other invasions of privacy. Later, as the world evolved and government scandals became apparent, the Privacy Act of 1974 was enacted, and perhaps is the most significant piece of privacy legislation. Why? Well, it restricts the way federal government may deal with private information about individual citizens. After the Watergate scandal, which involved the then President Richard Nixon, and eventually led to his resignation. You see, Nixon performed various data privacy breaches, including installing listening devices in telephones in the Washington headquarters. This led to many Americans losing faith in the government and the demand for greater transparency in politics and in data privacy laws. Consequently, the Privacy Act of 1974 severely limits the ability of federal government agencies to disclose private information to other people or agencies without the prior consent of the affected individuals. Important keynote: remember, the Privacy Act only applies to government agencies, not to companies and other organizations, aka private. The Act also has various exceptions alongside strict requirements around data retention and need. It also allows citizens to access and request corrections to any government record held about them. Now, those were the two Godfather-type laws around privacy. Then, as the world evolved and the internet began, more and more laws and amendments were needed. And so began the cat and mouse game of legislation trying to keep up with privacy laws, which even to this day remain very complex. After all, when we consider many early privacy laws were designed around physical wiretapping, such as the Federal Wiretap Act, with no concept of electronic communications. This soon changed with the Electronic Communications Privacy Act of 1986, ECPA, which makes it a crime to invade the electronic privacy of an individual. The ECPA Act broadened the Federal Wiretap Act, which previously only covered communications traveling via a physical wire, to apply more broadly to any illegal interception of electronic communications, such as email, voicemail communications, and also provides various situations where disclosure is legal and illegal, alongside some hefty fines and prison sentences. Talking of prisons, this soon led to the Communications Assistance for Law Enforcement Act, CALEA, of 1994, which amended the Electronic Communications Privacy Act of 1986. The Communications Assistance for Law Enforcement Act requires all communication carriers, such as Internet service providers, to make wiretaps possible for law enforcement with an appropriate court order, regardless of the technology in use. In other words, the start of digital police. This need for digital policing was perhaps made evident in the next law known as the Economic Espionage Act of 1996, which extended the definition of property to include proprietary economic information so that theft of this information can also be considered industrial or corporate espionage. This changed the legal definition of theft so that it was no longer restricted by physical constraints, e.g., the Federal Wiretap Act. A great example of a recent US case of corporate espionage was the US whistleblower, ex NSA contractor known as Edward Snowden, who released many secret documents on a website known as WikiLeaks, which allegedly detailed the CIA's hacking methods of its citizens and spying tactics. This was a very controversial and arguably grey case. However, under the Act, there are multiple hefty charges and long prison sentences if found guilty. Hence, Snowden sought asylum in various geopolitical loopholes. By 1998, the internet was getting so complex that the president signed the Identity Theft and Assumption Deterrence Act, which again amended the digital landscape. As, believe it or not, in the past, the only legal victims of identity theft were the creditors, aka the banks, that were actually defrauded rather than the customers, aka you or me. Crazy, right, when compared to today? Hence, this act was very important at the time, making identity theft a crime against the person whose identity was stolen and providing severe criminal penalties up to a 15-year prison term and again some hefty fines for anyone found guilty of violating this law. Further laws were also needed to protect children and educational sectors against digital crimes. The Children's Online Privacy Protection Act of 1998, known as COPPA, made a series of demands on websites that cater to children or knowingly collect information from children. Such provisions required websites to have privacy notices and parents having the opportunity to review any information collected on their children, and perhaps most importantly, any children under the age of 13 requiring parental verifiable consent to have their information collected. Another similar law was known as the Family Educational Rights and Privacy Act, FERPA, FERPA, another specialized privacy bill that affects any educational institution that accepts any form of funding from the federal government, being the vast majority of schools. FERPA grants certain privacy rights to students older than 18 and to the parents of minor students. and is around the sharing and data retention of student records. Moving on to the healthcare sector and the well-known Health Insurance Portability and Accountability Act of 1996, HIPAA, which made numerous changes to the laws governing health insurance and health maintenance organizations, HMOs. Among the provisions of HIPAA are privacy and security regulations requiring strict security measures for hospitals, physicians, insurance companies, and other organizations that process or store private medical information about individuals. And as you guessed, in 2009, a further amendment was made to the HIPAA provisions through a new act known as the Health Information Technology for Economic and Clinical Health Act, known as HITECH. The key takeaway of HITECH was the way in which it treats business associates, aka organizations that handle protected health information, PHI, on behalf of a HIPAA covered entity, and the liability around this data, as well as data breach notification requirements. In regards to the financial sector, the key law is the Gramm-Leach-Bliley Act of 1999, GLBA, which somewhat relaxed strict governmental barriers which existed historically between financial institutions and the data they could share among each other. It also arose after a failed Hot News merger, which violated various privacy rules, which was the Citibank and the Travelers Company, who wanted to merge back in the 90s to form the Citi Group. You can Google that for more information. But fundamentally, the subsequent GLBA law created a number of limitations on the types of information that could be exchanged even among subsidiaries of the same corporation, and required financial institutions to provide written privacy policies to all their customers. The next law involves national security following the 9/11 attacks in America, which led to the USA Patriot Act of 2001, which stands for the Uniting and Strengthening America by providing appropriate tools required to intercept and obstruct terrorism, aka Patriot, which greatly broadened the powers of law enforcement organizations and intelligence agencies across a number of areas, including when monitoring electronic communications. One major change prompted by the Patriot Act revolves around the way government agents obtain wiretapping authorizations. You see, historically, police could only obtain warrants for only one circuit at a time, after proving that the circuit was used by someone subject to monitoring. The Patriot Act now allowed authorities to obtain blanket authorizations for a person and then monitor all the communications to or from that person under just a single warrant. Other noteworthy changes were the way government deal with Internet Service Providers, ISPs, when obtaining detailed information on user activity through the use of a subpoena, aka court order, as opposed to a wiretap. Other takeaways were the Patriot Act amends the jail terms, increasing up to 20 years, and once again expanding and amending the coverage of the original Computer Fraud and Abuse Act. Interestingly, the Patriot Act has a complex legislative history, not surprising given its far reaching privacy implications. And finally, I wanted to take a moment to briefly explain some cross border information sharing, specifically between the United States and the European Union (EU). Historically, the European Union and the United States operated a safe harbor agreement called Privacy Shield. However, this is no longer the case after a 2020 ruling by the European Court of Justice, declaring the EU US Privacy Shield invalid, meaning currently companies must not rely on the Privacy Shield and instead must use standard contractual clauses or binding corporate rules. In an upcoming video, we shall discuss European laws including the General Data Protection Regulation (GDPR). But ultimately, from this video, you can see that law is very complex and sometimes grey. Therefore, it is always advised to seek legal counsel or attorneys or data privacy professionals if you are ever in doubt to your legal position. And for those of you still watching this video, I really hope you enjoyed today's content as much as I enjoyed creating it. Please be sure to like and subscribe if not already to ensure you do not miss any future content like this. Also, I would like to say a special thanks to all our current subscribers. I started this channel in January 2025 and am sincerely humbled by all the support and growth we have achieved in just a few months alone. Thank you once again.